Welcome back to r/LegalAdvice, where people ask questions, get advice, and we get satisfaction. If you are new to my channel, please don't forget to subscribe to join our amazing community, and without any further ado, let's dive right into the stories. This one is titled "Landlord Never Created an Inventory, Now Wants to Deduct Damages." I am moving out of my apartment that I've been living in the last 2 years. Through that time, it has always been managed by the landlord, who has been grossly negligent in his responsibilities. While the deposit was held in a TDS, none of the required paperwork was ever provided, no gas certificate, TDS documentation, how to rent dogs, etc. Nor was an inventory ever created across no less than 3 tenancy periods and 3 different tenants, all joint tenants. Now I am moving out, the landlord is wanting to claim damages to the living room floor, as there is a small amount of damage to it, beyond wear and tear. My understanding is that as no inventory was ever created, there would be no way of claiming this money back through the deposit, as an arbitrator would instantly throw it out, and even pursuing it through the small claims court would be in vain. Am I right in this presumption? Other information: joint tenancy. Update: all 3 deposit schemes have confirmed that they cannot find my name linked to any deposit at the address, indicating the landlord has not protected it correctly. He claimed to have had the previous names of the tenants changed to the new ones at the time of the contract signed, but no deposit information can be found for them either. And a user answered in the comments in regard to, is the OP right in this presumption? Yes, you are incorrect actually. Claims are not rendered invalid in the absence of an inventory, it simply is one less piece of evidence the landlord has. If the landlord can show on balance on probabilities that you damaged the carpet, you will be liable. However, since he's not entitled to the betterment, you can argue he is entitled to market value only, or the cost of putting the damage right. Update: landlord never protected deposit, wants to withhold furniture for damages. Previously I posted regarding my landlord wanting to claim money for damages even though an inventory was never created. Now the landlord is wanting to withhold furniture as payment for the damage. I have checked with all 3 deposit schemes and they confirmed that a deposit has never been protected at that property, not since the landlord purchased the property. In the past, he has arranged for tenants to swap deposit money between themselves under the claim that the names on the registered deposit would be changed, which I have in writing, emails with a claim that TDS would be used on the contract. So my question is, what should be my next steps? If he withholds the furniture and returns all of my deposit, am I still able to legally seek compensation if the entire deposit has been returned? Should I seek compensation given that he never protected my deposit on not 1 but 2 ASTs? As the ASTs were both joint tenancies, would the other tenant also have to be involved, or can I pursue this myself for my section of the deposit? Update: following legal advice, a solicitor will be taking on this claim for both ASTs, will update with results. And a user in the comments gave very good advice, and the person said, I am not a lawyer, but take him to court, but move out first. Don't threaten him, just push it all to email and record it. We had some similar bullcrap with an old landlord, but one of us was a law student, he did all the legwork, but basically you have to follow a process. As it is a joint tenancy, make sure that the others are on board. Keep your mouth shut and take it on the chin, push everything via email. Request the deposit back, argue the toss over the return for as long as possible, don't accept any deductions and make sure it comes to you from his account directly and not from another person. Then, once he is paid what he's going to, issue a demand in writing noticing that he did not protect the deposit. Note the act that the judge will order him to pay you 1 to 3 times more, let him drag it out with bullcrap, record it all, reject any offer less than 1 times your deposit, additional to already refunded. This is compensation and the minimum due in court. Push for mediation, split the cost. If he refuses, that is ammo for court. File and make sure you claim costs, including all evidence of him being a scumbag and the confirmation that he did not protect the deposit. Next, go to court, state what happened and let the hammer fall. We got compensation of £90 each for the day missed of work, on top of the £300 for court fees and 1.5 times our deposit. I know this sounds harsh, but if they haven't protected their deposit, I would expect that they have neglected other duties along the way. Ours was so bad, rebuilt a wall while we were all living there and only told us about it after we all signed the contract. I gotta say guys, this is strangely specific advice considering that the person claims he or she is not a lawyer. I gotta say guys, if you would have a legal issue, would you really come to legal advice and follow the advice in the comments? I guess if you are totally broke, that is probably a valid choice, but in case you have some cash, I would rather contact a lawyer. Especially if it is a very important matter. And the last update to the landlord story. Landlord didn't protect deposit for multiple tenancies, just settled for £20,000. Just over a year later and the case is finally shut without having ever gone to court. After looking into it, the solicitor realized that the landlord did not protect any of her tenancies for a total of 4, each with a total of £3,300, making the total possible fine by a court up to 3 times the deposit being £39,600, not including fees. However, what I learned is that these cases are not straightforward if you're not close with the other flatmates. One of them refused to take part in the case out of concern it could go wrong. There was no way it could, but he was paranoid and another wasn't made aware of the claim. The result was one of the claims was dropped as part as settling for 2 times the first tenancy, 1 times the second tenancy and 3 times the third tenancy, coming to a settlement amount just shy of £20,000. I chose a no-win, no-fee solicitor, which made the process a lot less stressful as I knew it was either something or nothing at no cost to myself, and the winning fee taken, 26% in my opinion, was worth them taking on the year-long case at no expense to myself. It has been a wild ride, but it is over. I am financially better off for it, and hopefully this is the lesson needed to make sure the landlord will stop breaking the law. And guys, if you have watched until here, please don't forget to post some star emojis in the comments and also like the video if you want to support me. Thank you very much in advance, and in addition, I would love to know if you ever had any bad experiences with landlords. Let us know in the comments. And the next one is titled, Neighbor has removed my fence to facilitate installation of a garden tool shed partially on my land. Long story short, I thought I would be nice and allow my neighbor to take down part of my fence to enable her to fit in her shed. She explained she wanted 4 inches, less than the thickness of my fence, so okay. The next day I find 14 inches of shed in my garden, a mattress shoved down the back of it, creating a water trap on my back wall, and my fuchsias crushed. Am I within my right to lift and remove her shed from my property without asking? I just want to put my fence back up. Thanks for any help, hope you are all having a great day. Edit, living in South England. Update, if this is how you do an update. So, after all of you wonderful people's advice and finally making a rather unpleasant contact with the neighbor, I have taken loads of photos and videos, more than I did before. I have also spoken with the nice neighbors and got them to witness me re-erecting my fence directly in front of her shed, right on my original boundary. The shed door now cannot open. Oh well, balls in her court now. Thanks again for all your help everyone, I hope you are all having a most awesome day. And the advice for this was, not a lawyer but very experienced with neighbors. I would talk to her first. It is not good to start a war with neighbors no matter how unreasonable they are being. You never want to turn unreasonable into downright nasty when you live next door to someone. I would go around and say you've got a couple of issues and would like to have a chat about it, and then go around and show it to them from your side. Ask why it is so much further over and why there is a mattress there. State that you need them to move it forward about a foot. It is possible that the person who put it in did a crappy job and they have not looked at it from your side of the fence. I would stay calm for the moment, get them to come and look at your side and explain very nicely why it is an issue and ask what they are going to do. If you just move it, no matter how within your rights you are, there is a chance you will end up in a petty battle with them for the rest of your time there. They could easily claim that you damaged the shed, for example. Also, I would take some photos. And the next one is titled US/UK, I may have committed some light treason. Throwaway for anonymity and my company's confidentiality. Also, because I cannot resist a good Arrested Development reference. This is a serious question though. I am a US citizen living and working in the UK. I am a biologist at a small biotech company, a startup really. We make laboratory supplies for molecular biology experiments. Yesterday I overheard my boss and our logistics manager talking about an unusual customer. The order had originally come by email from a company in Syria, but then they had received a call from the customer asking if they could instead deliver to an address in London and he would take the supplies back in his luggage. My boss said, sure, why not? It sparked some discussion afterwards because it is unusual, but we figured that the delivery infrastructure in Syria is probably not at 100% right now. I was only half paying attention to the conversation as I normally don't deal directly with customers and I was doing my own work. Later that day we got a phone call which I picked up because everyone else was occupied. It was the customer from Syria saying that he had originally been quoted a price in US dollars and could I please send him a quote in British pounds so he could transfer the money. I got the okay from my boss, put together a quick quote, gave it to him over the phone. That evening I was talking about this with my husband at home and he looked concerned. He says, you know that as an American you are prohibited from doing business with Syria, right? Really? So today I did some googling and it looks like he's right. According to this, US people are not permitted to do business with individuals or entities that are part of or supporting the Assad regime. The billing address is in Damascus, so it seems likely that it is in at least the region controlled by Assad. I don't think my company is violating any UK laws by dealing with this customer. It looks like the UK only has an embargo on arms and some energy industry stuff. Our products are completely benign, we are not selling anthrax or anything. The customer's company does not have a website, but their name suggests that they are a medical supply company, which would make sense as our products are often used in diagnostic kits. I have no ownership interest in the company, I am just an employee. Did I break the law? Should I contact a lawyer? And a person in the comments said, you did not break the law, you did not do business with this entity by answering the phone and giving him a translation to GBP. And another person in the comments said, I don't think you did anything wrong, but your company would be well advised to do a little more research into the UK's embargo list for Syria. If they are just shipping off a bunch of glassware, they should be fine, but anything more complicated should be reviewed. The full list of the UK's embargo items is much larger and includes biological weapons and chemicals, including any equipment that could be used to make them. Some items are entirely restricted and others require a specific license. A few examples: distillation or absorption columns of internal diameter greater than 0.1 meters, where all surfaces that come in direct contact with the fluids being processed are made from the following materials: stainless steels with more than or equal to 10.5% chromium and less than or equal to 1.2% carbon. Batch centrifuges with a rotor capacity of 4 liters or greater, usable with biological materials. You get the idea. Other restricted items include protection and detection equipment, such as gas masks and other protective suits, certain valves, vacuum pumps. See a full list here. Update: I may have committed some light treason. Thanks to everyone who put in their 2 cents last time. I talked to a US lawyer last week who specializes in international law, and his opinion was that I did technically break the law, but in such a minor way that he cannot imagine anyone ever trying to prosecute me. He said it did not rise to the level of voluntary disclosure. However, he did say I should refrain from having any more contact with customers from Syria, as well as other sanctioned countries such as North Korea, DRC, etc. He sent me a link to the relevant treasury document. Prohibited transactions are on page 4. So to those who said I was not liable because it was the company's decision, not mine, that is not true. The Department of Treasury prohibits the direct or indirect exportation, re-exportation, sale or supply of any services to Syria from the US or by a US person wherever located. So just for your information, for any other Americans working abroad, if your boss is asking you to broker a sale or give customer support to someone in Syria, you could be breaking the law. I gotta be honest guys, this person's boss sounds like an absolute idiot, because what sort of company owner or boss does not know that a US company currently should not make any deals with Syria? I mean, that is probably common knowledge even for high schoolers. And the last one is titled, Apartment Complex Threatened to Sue Me After I Attempted to Back Out of the Lease. To summarize, I am a student entering my final semester of undergrad at PSU. I had intentions of signing a lease last year at a new apartment complex this upcoming fall prior to the entire pandemic happening. Recently, I was presented with the option of either paying a security deposit or getting a guarantor to finalize my lease. Now, I did sign some stuff online, however, I did not give them financial information and did not pay a security deposit or even get a guarantor. This past week, I did a lot of reflecting on my future for school. I do not want to move into an apartment and attend school at University Park since the cases are rising and everything will shut down again. I weighed my options carefully and concluded it would be in my best interest to leave the apartment before I even move in and do an online semester from home, saving me thousands of dollars. Now, I am from a relatively poor background, my family is working class and I work for everything. I never could afford their security deposit of $1,700 and I could not get a guarantor. This morning I called the office and explained everything to the leasing manager. I simply told her that because I cannot afford the security deposit or find a suitable guarantor, I would like to cancel my lease. I was under the impression that because it was not fully completed, they would begrudgingly allow it. However, they have said since I signed my portion, I am legally obligated to go. And if I did not go or find a replacement, which they want a replacement in under a month, which is nigh impossible, they would sue me and make me pay next year at the end of the 12-year lease. What can I do? I can provide additional information for more context if requested. I simply told her that I am most certainly not going to Penn State this fall, and apparently many are trying to get out of their lease as well there. So I understand they are trying to manage a tough situation, but I am in an even tighter financial hole currently. They gave me zero wiggle room to find an alternative besides finding a replacement, which is a pipe dream at best. And a user in the comments said, if you signed a lease, no one is obligated to cancel it for you. That is the point of it. Sucks, but unless you find a replacement, they can go after you. Check what you signed as to what it says when trying to break a lease. Typically, there is a lease break fee or you are financially responsible for the unit till someone moves in or the lease expires. Update to the lease story. After no contact with the apartment complex for a few days, I began contacting a few legal experts after receiving some very helpful advice from Reddit. Going forward, I spoke to the leasing manager after acquiring several documents showing the lease to be invalidated and void if I did not acquire a guarantor. And to my surprise, they completely dropped the ordeal. Currently, I've been advised to send a letter of confirmation that I am not going to be living there on the basis that I have no guarantor. It is possible to break a lease if they state you cannot move in without providing a guarantor. Remember to reread your leases before they entrap you. And guys, I would say that is pretty sound advice, and not only leases, this pretty much applies to anything you sign. No matter whether you are old or young, whenever someone wants you to sign something, no matter how long the document is, please read it before signing anything. Have you guys ever been in a situation where you signed a contract or any sort of document that later got you in huge trouble because you did not really read the document beforehand? Let us know in the comments. But unfortunately, this was the last story for today, and in case you haven't already, please don't forget to check out my Patreon at patreon.com/ripeyoutube for more exclusive Reddit content that you won't find anywhere else. And yes, this includes Just No Mother-in-Law in case you are interested in that topic. Either way, thank you so much for watching and for supporting me daily. I hope you have a fantastic day, and I see you again tomorrow.